Then I give floor to my colleague, Aiga.
Thank you, Martins. Good afternoon. I'm Aiga Benfelde, and it's my privilege and pleasure to meet you all once again, already for the third year. And my today's presentation will partly be linked to the presentation I did last year, but we find still several of those topics quite significant to be reminded and you to be introduced. So therefore my presentation will be regarding the changes in the public procurement legislation. Before we start with the changes, first of all, I would like to remind, as already colleagues have said, RB Rail as a three Baltic state joint venture is procuring under Latvian public procurement law, and national implementing bodies are procuring under the law of each of the countries, Latvia, Estonia, and Lithuania. Therefore, in my presentation, I will more focus on the changes in the Latvian public procurement law. Also, I can say that we had a discussion with our colleagues, and currently in Estonia and Lithuania, there are no major changes in the legislation. Therefore, we are now focusing more on the Latvian law. And here on the slides, I also have put some links for your information. The link to Latvian e-tendering system where you can find our procurements, also ongoing ones and archive. So you can take a look on the opportunities for those procurements where you would like to participate. And also, there is a link to manual how to register in e-tendering system, because you cannot participate in any of our procurements if you're not registered there. It takes a bit of time. It's not a straightforward process. Therefore, I kindly ask you to register in the system if you haven't done it yet. And now going to the subject of this presentation. First is exclusion ground related to the tax debts of the suppliers. So before the threshold in Latvian public procurement law was 150 euros. So it means that any supplier should have less than 150 euros tax debt, both in the residence country of the supplier as well as here in Latvia. Now Latvian public procurement law has actually restored the requirement as it stands in the public procurement directive. So this means that the supplier can have a tax debt in a threshold what is established in the residence country of the supplier. And in Latvia, the supplier has to have at least the less than 150 euros tax debt. So it means if, for example, in your residence country, this threshold is 1,000 euros, then this is the amount of tax debts what you can have to participate in the procurements. And here in Latvia, you need to have 150 euros, not more. And I want to remind also regarding these changes that this is something that is applicable to those procurements what have been published starting from 1st of January this year. So this means if we speak about the consolidated material supply procurements, also and CCS design and build and procurements, which have been published in 2021-2022. So for these procurements, these new changes are not applicable. So therefore, please, those suppliers, keep an eye on your tax debts. There, this 150 euro threshold stays for both the residence country of the supplier and also for the Latvian. Second topic, I would say, is the main driver of the procurement process, because without competition, I would say, procurement process would be useless. Therefore, legislator has gone one step towards giving more authorization to the Procurement Commission, Contracting Authority, and also Competition Council. So there are new cases when the contracting authority can exclude the supplier in case there are strong indications that these suppliers have an agreement which is disturbing or restricting the competition, and that in such case actually the contracting authority can already exclude a supplier, not waiting for the court decision which has been taken and been unappealable. And also for the Competition Council here in Latvia, this authority has been extended, so also the opinion of this Competition Council can be as an argument or justification for the Procurement Commission to exclude the supplier. So therefore, again, it's not only the court's decision, but also a Competition Council opinion that can be used as a reasoning for exclusion. As usually, there are some exceptions. I would say the main exception is the years. So if 3 years have been passed from the court decision or the moment when this violation of competition has been established, if these 3 years have been passed, then it means that the Procurement Commission is not allowed to exclude the supplier. And also exception is in those cases if that particular supplier has been cooperating with this particular authority, state authority, and this supplier has received immunity. So this means that with this cooperation, that supplier has taken off this restriction to be excluded. Going forward to the list of the persons who must be checked against the exclusion grounds, here again, legislator has extended the list. So there has new persons in the list added that previously we did not check. Beneficial owner is one of them. Yes, we checked it in light of sanction law, but not public procurement law. Now it is also here. And also the persons with decisive influence. This is something new. So therefore, when you apply to the procurement and you are addressing also with your documents non-existence of exclusion grounds, it is important that you identify those persons in your company and you already address this topic in the documents when you submit your exclusion ground documents to the Procurement Commission. And also with regards to subcontractors, then there this threshold has been lowered, so it means that previously the Procurement Commission had to check exclusion grounds against those subcontractors to whom only 10% of the total contract value has been subcontracted, and now it is lowered to 10,000 euros. So I would say in our project this means that almost every subcontractor attracted to our contracts has to be checked. Continuing subcontractors topic, 2 items what I wanted to emphasize. During the procurement process, please be aware that you are allowed to indicate and include in your proposal several subcontractors for the same scope. So it means if you, during the procurement process, you don't know exactly with which solution you will go further during the contract execution, or there are different options, it is allowed for you to indicate several of those subcontractors for the same scope, and then during the contract execution to decide and choose with which of them, one of them or several of them you want to basically during contract execution perform the works. And in this case, yes, you have the possibility to indicate all of them, but it means also that all of them will be checked against the exclusion grounds. Other thing is that during contract execution as well, at any point in time, you are allowed to add any new subcontractor, either by substituting one of the existing ones or adding a completely new one subcontractor. But then again, please be aware that these subcontractors will be checked against non-existence of exclusion grounds. And getting to the end of my presentation, one new item, what is now introduced in the public procurement law of Latvia, that was not there before. But I would say in our Rail Baltica project we are applying it from, I would say, day one. This is economically most advantageous criteria. And now in the public procurement law it is clearly stated for which subject matters this meet criteria is a mandatory to be applied. So as I said, I would say in Rail Baltica we have this practice since day one for the design and build procurements. We usually use not only price but also other criteria, and here some of them have been mentioned also as a good practice, and I can confirm that also these ones and other ones we are applying in our all main procurements. So thank you. This is all from my side, and thank you, and looking forward meeting you in our procurements. And now I give floor to my colleague Elina.